Welcome, future real estate champions, to another deep dive in our ACE Your RES Exam Key Topic Deep Dive series.
Great to be back.
Today, we're tackling a topic that often feels like, well, untangling a complex knot. The incredibly important world of subleasing and assignments in property transactions.
Yeah, it can definitely seem that way.
This isn't just theory, everyone. It's practical, crucial knowledge for any real estate professional here in Singapore, and definitely a hot topic for your upcoming RES exam.
That's right. Our mission today is really to cut through all that complexity, giving you a clear roadmap. We're going to clarify the core distinctions between these two concepts, weigh the practical pros and cons from, every angle.
Landlord, tenant.
Exactly. And peel back the layers of legal intricacies that make them so, well, interesting maybe.
Interesting or just tricky?
Both. Think of this as your shortcut to truly understanding this subject, packed with practical insights that will give you a real edge, especially for that exam.
All right, let's dive in. Let's untangle this from the very beginning. What exactly is subletting or subleasing? Lay it out for us.
Okay, so at its core, subletting is when you, as the original tenant, rent out maybe a portion or even all of your leased property, but only for a temporary period.
Right, temporary.
And crucially, your name stays firmly on the main lease with the landlord. You effectively become the sublessor.
Right, I'm the sublessor.
And the new person you bring in is the sublessee.
Got it. So like your example earlier, if I've got 6 months left on my 12-month lease, but a fantastic job offer pops up in, say, another state.
Yep.
I don't want to break my lease, obviously. So I find someone to take over for those 6 months. I'm still the main contact with the landlord, but someone else is hopefully paying me rent and living there.
That's it. That's a sublease in a nutshell. You got it.
Okay.
Now contrast that with an assignment. An assignment is a much more complete transfer. Exactly. It's when a tenant transfers their entire remaining interest in a lease to a new party. And here's the kicker. They don't retain any reversionary interest.
Reversionary interest. Okay, what does that actually mean?
It just means the original tenant doesn't get the property back at the end of the term. It's a full handover. Done. Finished.
Okay. So the key distinction really boils down to that reversionary interest and something called privity. That sounds very legalistic.
It is a bit technical, yeah.
But it's central to understanding liability, isn't it? Who's on the hook?
Absolutely crucial. In a sublease, the original tenant, the sublessor, retains that reversionary interest.
Meaning they get it back.
Right. They have the right to get the property back at the end of the sublease term. And the landlord, in this scenario, retains privity of contract with you, the original tenant.
So the landlord's main deal is still with me?
Precisely. Their primary contractual relationship for things like rent payment and, following the lease rules is still squarely with you, not the sublease directly.
So as my sublessee flakes on the rent?
Guess who the landlord calls first?
Me. Ouch.
Yep. Now, with an assignment, how does that shift? Well, the original tenant does not retain a reversionary interest.
You're out.
They're transferring all their rights and obligations for the rest of the lease. And here's where the privity changes. The landlord and the new tenant, the assignee, they gain both privity of contract and privity of estate.
Okay, privity of estate. What does that add?
It basically allows the landlord to enforce the lease terms directly against the assignee. They have that direct legal link now for both the contract and the property itself.
And here's where it gets really important for any agent advising a client, right?
Mm-hmm.
And definitely for the RES exam. Even with an assignment, the original tenant often remains liable for breaches.
Still potentially on the hook.
Unless there's that magic word, a novation.
Exactly. Unless a novation by the landlord explicitly releases them. That's the specific legal release your client wants to hear if they want to be truly completely off the hook.
Because without it, imagine them getting sued years later for someone else's unpaid rent or damages.
It happens. A novation is essentially a brand new contract that completely replaces the old one, legally releasing the original tenant from their obligations. Without that explicit novation, the original tenant stays in the landlord's line of sight, legally speaking, even if they moved out long ago.
Wow. Okay, that's a huge takeaway right there. So let's pivot back to subleasing then. You called it a double-edged sword, especially for landlords. It offers both benefits and some pretty significant risks.
It absolutely is. Let's look at some of the clear upsides from a landlord's perspective first. One major advantage is, well, financial stability.
Money keeps flowing.
Pretty much. If you're open to subleasing, you're almost guaranteeing a constant flow of rental income, even if your main tenant needs to leave early. It acts as a significant financial safety net.
And they don't have to scramble to find new tenants themselves. That sounds like a huge relief for any property owner, especially in a market like Singapore.
It definitely is. Think about the time and stress saved. Your current tenant takes on the responsibility of finding new occupants. They essentially become a kind of mini property manager for that space,
Right, doing the legwork.
which alleviates a massive burden and, it can sometimes lead to better property upkeep too.
How so?
Well, tenants who sublease are often pretty invested in finding and keeping good subtenants, right? Which means they'll likely take greater responsibility for the property's condition. That could potentially reduce your maintenance time and money as the landlord.
Interesting point. And what about the original tenant? Is there a financial perk for them in this subleasing deal?
Sometimes, yeah. Original leaseholders might be able to charge subtenants slightly higher rent than what they pay the landlord.
Little profit margin.
Exactly, creating a small profit for themselves. And subleasees often agree to this because they really value the flexibility and maybe the shorter-term nature of these agreements. Meanwhile, the landlord still gets their consistent, agreed-upon rent. It can be win-win-ish.
And who doesn't love the idea of a short-term arrangement potentially blossoming into a long-term commitment, like a trial run?
That's definitely the dream scenario for landlords. The possibility of a short-term subtenant really liking the place and then becoming a long-term leaseholder.
Signing a proper lease directly?
Right, they sign a new regular lease directly with the landlord. That saves the landlord future tenant hunting efforts and lowers vacancy risks. It's almost like a try before you buy for tenants and a lower risk way for landlords to find new, potentially stable occupants.
Okay, those are some pretty compelling upsides. But as we said, it's a double-edged sword. Where's the downside for landlords? What are the risks they're taking on?
The first major risk is a lack of control, specifically control over the sublease agreement itself.
They're not party to that subdeal directly.
Exactly. Landlords may not have a direct say in who their tenants sublease to, which can lead to, let's say, unhappiness with the subtenants or disputes over property upkeep. Without a very carefully drafted master lease and consent agreement, things can get messy fast.
Because you're essentially trusting your original tenant to screen the new person properly. What if the original tenant isn't trustworthy or just, doesn't do a good job vetting?
That's a significant concern, absolutely.
Yeah.
Problems definitely arise if original tenants don't properly screen subtenants, or maybe they fail to collect rent consistently.
And then the landlord has to chase the original tenant, who then has to chase the subtenant.
It gets complicated. And it gets even worse if the primary tenant suddenly vanishes, just abandons their duties. That can leave the subtenant, and by extension the landlord, in a really difficult spot. Potential financial loss, legal headaches. It's not pretty.
And I imagine more turnover generally means more wear and tear on a property, too.
It certainly can. Temporary subtenants, let's be honest, often don't show the same level of care as long-term ones who feel more invested.
Makes sense.
This can result in more frequent property damage, from maybe minor cosmetic stuff to potentially more serious structural issues. And the burden of repair, of course, often falls squarely on the landlord.
And then there are the neighbors to consider, right? In an HDB block or a condo, a constantly changing stream of occupants could lead to complaints.
Absolutely, that's a big one. Plus, evicting an unknown subtenant, someone you have no direct contract with, can be a legal nightmare.
Because your primary agreement is with the original tenant.
Exactly. And frequent changes in occupants can really disrupt the tranquility of a residential area, potentially tarnishing the property's reputation or leading to neighborhood disputes that you, as the landlord, suddenly have to manage.
So that potential short-term gain from flexible subleasing could actually become a long-term headache for stability and community vibes.
Precisely. There's just no guarantee that those short-term subleases will become those stable long-term tenants you hope for. If it's not strategically managed, routine short-term subleasing might actually hinder a landlord's chance of securing stable, long-term leases, potentially leading to financial instability or ongoing community disturbances.
Wow, so many variables. It's definitely not simple. Clearly, subleasing isn't just a handshake. It's kind of a minefield of potential issues. But let's shift focus slightly. What about the tenant trying to get out of their lease, or the new party looking for space? Their needs are completely different, right?
Completely different agendas.
And that's where the real art of negotiation comes in, I suppose. Let's dive into those competing interests and the key issues that always seem to pop up in any transfer, sublease, or assignment.
Yeah, what's fascinating here is how each party comes to the table with a very different set of goals.
Mhm.
The original tenant, or sublessor,
What do they want?
they primarily want to reduce their exposure, their liability, or ideally just exit the lease entirely, clean break.
Right.
They might even, try to use the threat of default or bankruptcy as leverage against the landlord, especially if economic times are tough.
Yeah.
And of course, they're thinking about how this impacts their future leasing ability, their creditworthiness.
Makes sense. And the landlord, they just want everything to stay exactly as they originally agreed, I bet. Keep it simple.
More or less. The landlord wants the original deal they bargained for, the rent they expected. They definitely want control over who occupies their property, and they absolutely want a financially strong, credit-worthy tenant.
Someone reliable.
Absolutely. What they definitely don't want is the headache or the transaction costs associated with the problematic transfer. They want smooth sailing.
And the assignee or subleasee coming in the new party, what's their angle?
They're typically looking for flexibility, right? Flexible space, maybe flexible rent options, perhaps a shorter-term arrangement that suits their immediate needs.
Could be cheaper sometimes, too.
Potentially, or at least avoids a long commitment. But they also face potentially higher risk and often higher transaction costs compared to just signing a direct lease with the landlord. It's a trade-off, a delicate balancing act of needs and priorities for everyone involved.
Okay, so with those competing interests floating around, what are the most crucial issues that need to be nailed down when any of these transfers happen? What should agents be looking out for?
Right, number one, and arguably one of the most crucial points, especially for understanding your client's liability and for the RES exam, is the residual liability of the original tenant.
We touched on this, but it's worth hammering home.
Absolutely. In a sublease, just to be crystal clear, the original tenant remains primarily liable to the landlord, full stop.
No escaping that.
In an assignment, the original tenant may remain liable for the assignee's obligations unless they are explicitly released by that novation we talked about. This is a huge point of negotiation because it determines who the landlord can legally pursue if things go wrong, unpaid rent, damages, you name it.
So the landlord might still come after the original tenant, even if they assign the lease and haven't been there for years. That's a massive responsibility to carry.
It absolutely is. Next up, think about the suitability of the space, especially if only part of the premises is being transferred.
Like subletting just one office in a larger suite?
Exactly.
Huh.
Can it actually be properly subdivided for the new tenant's intended use? Think about the practical costs, putting up new walls, installing separate utility meters, maybe even creating new entrances. Negotiating who bears these potentially significant costs is absolutely key.
Yeah, those fit-out costs can be huge.
It really can. And then, of course, the creditworthiness of the new tenant. This seems like a no-brainer for a landlord, right?
You'd think.
It's often top priority. If a lease is assigned from, say, a struggling business to a financially robust, well-known company, that's a clear win for the landlord.
Definitely.
But flip that. If a strong national tenant wants to assign their lease to a small, independent startup with no track record, well, that could be seen as a significant poor result for the landlord.
Because their risk just went up.
Exactly. The landlord might have negotiated the original terms based on the strong tenant's proven financial stability. So landlords will almost always require solid evidence of financial strength from the prospective transferee. Bank statements, financials, the works.
That makes perfect sense. Now, the proposed use of the premises is also hugely important, and you mentioned it varies a lot by the type of property.
It really, really does. For an office lease, okay, the specific type of office business generally matters less as long as it is office use. Though, transferring from a high-profile law firm to maybe a small call center could impact the building's overall status or image.
Perception matters.
It can. Industrial leases, however, are highly sensitive. Think about it. A woodworking shop has vastly different needs and impacts than a high-tech clean room or a food processing plant.
Noise, vibrations, smells.
Exactly. Considerations include floor load capacity, security needs, access for large vehicles, noise levels, potential odors, environmental concerns, traffic generation, parking requirements, and even potential interference with other tenants in the building. It's a long list.
And retail leases are notoriously the trickiest, you said, the prima donnas of leasing.
You could say that. They are often the most complex when it comes to assignments and subleases. Landlords are keenly concerned with their existing tenant mix.
Got to protect the vibe, the synergy.
Precisely. They worry about any use restrictions or exclusives already granted to other tenants. You can't have competing businesses right next door usually. Parking availability is always huge in retail. the potential for percentage rent generation from the new business.
Ah, because some retail leases have that rent based on sales.
Correct. And even things like signage requirements. All these factors play a huge role in the retail environment and whether a transfer makes sense for the landlord.
Okay, beyond the physical space and its use, what about existing rights baked into the original lease? Like options to extend? Do those automatically transfer?
Great question. That leads us to the ability of the transferee to exercise options. Generally, no, they don't automatically transfer.
Really?
Yeah. If the original lease includes options for the tenant, maybe to extend the term, expand into additional space, or even purchase the building, these valuable options may not travel with the transfer unless the landlord explicitly grants them to the new tenant in writing.
So the assignee doesn't just inherit everything.
Not usually the options, no. And in a sublease, it's even clearer. A subtenant typically won't have the right to exercise options held by the primary tenant without the landlord's explicit consent, usually in that three-way agreement.
Okay, that's critical. And I can definitely
Yeah.
see how a subtenant would want some protection. What if the main tenant defaults on the master lease? The subtenant could be kicked out even if they're paying their rent right, left high and dry.
Precisely the risk. That's where non-disturbance agreements or NDAs come in. They're crucial for subtenants.
How do they work?
Well, remember, a sublease is dependent on the master lease. If the master lease terminates for any reason, poof, the sublease terminates too.
Scary for the subtenant.
Very. So, to protect themselves, subtenants often seek a non-disturbance agreement directly from the landlord. This agreement basically says, hey, landlord, if the main tenant defaults, please don't kick me out as long as I'm paying my rent and following the rules.
So it creates a direct link for that specific purpose.
Yes, it ensures their sublease isn't terminated if the master lease ends, or sometimes it gives them the option to enter into a new direct lease with the landlord. These terms are, as you can imagine, highly negotiated, especially if the sublease rent is lower than the market rate or it's only for a portion of the space.
Makes sense. Now, what about this term waiver of subrogation? It sounds like legal jargon overload.
Ah, it does sound complex, but the concept is actually simpler than it sounds. Let's break it down.
Please do.
Imagine a small fire starts in the subtenant space due to faulty equipment. Their insurer pays for the damage, right?
Okay.
Now, without this waiver, that insurance company could potentially turn around and sue the landlord or even your client, the original tenant, claiming their negligence somehow contributed to the fire, trying to recover the money they paid out. That's subrogation, the insurer stepping into the shoes of the insured to sue.
So the waiver stops that.
Exactly. The waiver of subrogation simply means, look, we all agree, landlords, tenant, subtenant, that our own insurance policies will handle our respective damages for insurable events, like fire or water damage. No lawsuits between us or involving our insurers for these kinds of losses. It prevents insurers from pursuing claims against other parties to the lease for losses they've already paid out under a policy. It streamlines things and avoids finger-pointing after an insured loss.
Okay, that's much clearer. Good to know. And finally, you mentioned we can't forget the lender considerations, the bank behind the landlord.
Absolutely. The landlord's mortgage lender often has approval rights over certain transfers, especially major ones or assignments. Their loan documents might require it.
Another layer of bureaucracy.
Pretty much. So even if the landlord, the original tenant, and the new transferee all agree on the terms of an assignment or sublease, the landlord's lender might still have the final say, adding yet another layer of approval to the process. It's just a reminder that real estate is often this complex web of interconnected parties and interests.
So clearly, drafting these agreements, the lease itself, the sublease, the consent with absolute precision is just crucial. Let's talk about the legal framework itself, starting with those lease transfer provisions in the main lease. It's always a bit of a tug-of-war, isn't it? Landlords want control.
Maximum control.
And tenants want flexibility.
Maximum flexibility. Always. The ideal clause for a landlord might simply prohibit any transfer without their prior written consent, which they can withhold in their sole discretion, meaning for any reason or no reason at all.
Tough for the tenant.
Very. For a tenant, the dream clause would grant them the right to assign or sublet freely, maybe just with notice to the landlord. The reality, of course, almost always lies somewhere in the middle with heavily negotiated compromises.
And you often see the phrase that consent cannot be unreasonably withheld. How is reasonableness defined when a landlord denies a transfer? That sounds like something that could be argued endlessly.
It certainly can be, which is why it's best to define it in the lease. Landlords typically want to specify what constitutes a reasonable basis for denial, right there in the clause.
Like what?
Well, common reasonable grounds include the creditworthiness or net worth of the proposed transferee. A landlord shouldn't have to accept someone with a shaky financial history compared to the original tenant.
Makes sense.
Other factors could be the transferee's business experience or reputation, the physical suitability of the premises for their proposed use, whether that proposed use violates existing tenant mix rules or exclusives in the building.
Like putting a noisy gym next to a quiet library.
Exactly. Or even if the landlord happens to have other suitable vacant space available in the same building or project.
Ah, so a landlord might actually be able to say, hey, I have an empty unit down the hall that's perfect for that type of business, so you can't sublet yours to them. They want to fill their own space first.
Precisely. Landlords may also negotiate for recapture rights. This is a big one. It gives the landlord the option, if a tenant requests permission to transfer, to instead terminate the original lease and take back the premises altogether.
Wow, that gives them huge control.
It really does. And then there's the concept of sharing of excess rent. We touched on the tenant potentially profiting.
Right, charging the subtenant more?
Well, many master leases allow landlords to share in that profit, sometimes taking 50% or even 100% of the difference if the sublease rent exceeds the master lease rent.
What's the landlord's argument for that?
The argument is usually that the landlord, not the tenant, is the one primarily in the business of leasing space and taking the long-term risk on the property's value. Any upside from market rent increases, they argue, should belong to them. It's often seen as fair, especially if the tenant is essentially profiting from the landlord's asset.
Okay, I can see the logic. And what about big corporate tenants? They often merge or restructure. How is that handled?
Good point. Large entities, big companies, they almost always negotiate clauses for permitted transfers that don't require landlord consent for certain internal corporate events.
Like what kinds of events?
Things like a sale of the company, a merger with another entity, transfers to affiliated companies like subsidiaries or parent companies, or maybe even transfers for estate planning purposes for smaller businesses. This flexibility is crucial for their normal business dealings and restructuring.
Do landlords usually agree to that?
Landlords typically allow these, yes, but usually with conditions. Often the condition is that the resulting entity still has to meet certain financial strength tests, like having a minimum net worth, to ensure they can still fulfill the lease obligations.
Makes sense. And here's a big red flag for any agent listening and for the exam. If a tenant violates these transfer provisions, like subletting without permission when it's required, that's often an immediate default of the lease, right? Sometimes with no warning or cure period needed.
It absolutely can be. It's often considered a major breach. Now, let's zoom in on the sublease provisions themselves. This is the actual contract between the original tenant, the sublessor, and the new occupant, the sublessee. This document really defines their specific relationship and obligations to each other.
Okay, first up, gotta have landlord consent, right? If the main lease requires it.
Yes, absolutely fundamental. The master lease almost always requires the landlord's prior written consent for a sublease. The subtenant will want confirmation, usually evidence, that this consent has been properly obtained before they sign anything.
Makes sense. You don't want to move in and then get kicked out.
Exactly. And ideally, the sublease document itself should clearly state that it incorporates the provisions of the master lease by reference.
Why is that important?
It avoids gaps or contradictions. It makes sure the subtenant is legally bound to follow the same rules and regulations laid out in the original lease regarding things like use of the property, maintenance, alterations, rules of the building, etc. Makes the subtenant aware of the primary rules they have to live by.
So the sublessee is essentially agreeing to abide by the original lease terms, even though they're not technically a party to that original contract.
Largely, yes, for the operational parts.
Yeah.
And the term of the sublease logically absolutely cannot extend beyond the master lease term. It's derived from the master lease. It can't outlive it.
Right. Can't give away what you don't have.
Precisely. As for rent, the subtenant usually pays the sublessor directly, who then pays the main landlord under the master lease. And if the subtenant needs to make alterations to the space,
like putting up some internal walls or something?
Yeah. The sublessor must have the right under the master lease to allow those alterations, subject to landlord approval, usually. And there might even be a tenant improvement allowance negotiated between the sublessor and sublessee, using funds perhaps left over from the original lease negotiation.
Okay. And insurance always a huge one, especially with multiple parties involved now. How does that work?
Critically important, yes. The subtenant is responsible for getting their own insurance, covering their own operations, and liability within the sublease space. This typically includes commercial general liability insurance.
And who needs to be covered by that policy?
The master landlord and the sublessor, the original tenant, should always be named as additional insureds on the subtenant's policy.
Why? What does that do?
It acts as an extra layer of protection for them. If someone visiting the subtenant slips and falls in the subleased area and sues, the landlord and sublessor want the subtenant's insurance policy to defend and cover that claim first.
Got it. An extra shield.
Exactly. And don't forget that mutual waiver of subrogation we discussed. You want that included in the sublease and the consent agreement, too. It just reinforces that everyone's property insurance handles their own property damage without cross lawsuits between the parties or their insurers.
And you mentioned a typical amount for liability. Good for the exam, maybe.
Yeah, a common requirement for commercial general liability might be at least $1 million per occurrence, sometimes more depending on the business and the property.
Okay, $1 million general liability. Noted. What about the subtenant's rights against the main landlord? Do they have any way to enforce things if the landlord isn't providing services, like air conditioning or cleaning?
That's a tricky point because there's no direct contract usually. The subtenant's contract is with the sublessor. So the subtenant often wants a clause in the sublease, giving them the right to compel the sublessor, the original tenant, to enforce the landlord's obligations under the master lease.
So the subtenant pushes the sublessor to push the landlord.
Kind of, yes.
Mm-hmm.
Especially for crucial things like essential services or utilities, ensures they have some mechanism to get what they're paying for, indirectly. And finally, the sublease typically incorporates the remedies available under the master lease, essentially giving the sublessor the same rights against the subtenant, like eviction for non-payment, as the main landlord has against the sublessor. It creates that clear chain of responsibility and enforcement.
This all sounds like a lot of intricate paperwork to get exactly right. Which brings us to the landlord's consent to sublease. This sounds like the linchpin document, the crucial three-party agreement tying everything together.
It truly is. It's absolutely vital. This three-party agreement clarifies the specific rights and obligations among the landlord, the original tenant, sublessor, and the subtenant, sublessee. It makes everything explicit.
What are the key things it needs to cover?
Well, first, it usually confirms the subordination of the sublease to the master lease, meaning if there's ever a conflict between the terms of the two documents, the master lease terms will control. The master lease is king.
Okay, hierarchy established.
Right. It also clearly identifies the rights and obligations of the subtenant directly to the landlord. For example, it might specify certain rules the subtenant must follow, or maybe even certain payments, like utilities sometimes, the subtenant pays directly to the landlord. And, importantly, it clarifies what rights the subtenant doesn't have, like those valuable extension options or expansion rights that belong to the original tenant under the master lease.
Managing expectations.
Exactly. And the landlord often gets a really important protection in this document: an assignment of sublease rent from the original tenant.
Okay, explain that again. How does that assignment work in practice?
Think of it like this. The original tenant agrees, right there in the consent document, that if they default on their master lease obligations, like paying rent to the landlord automatically has the right to collect the rent directly from the subtenant.
So the subtenant's rent payments get diverted straight to the landlord.
Correct. This assignment usually sits dormant as long as the original tenant is fulfilling their obligations. But the moment they default, this clause kicks in. It's often coupled with the subtenant agreeing to attorn to the landlord.
Corn, another legal term.
Just means the subtenant formally agrees to recognize the landlord as their new direct landlord in the event of the original tenant's default. They'll start paying rent directly to the landlord and dealing with them going forward. It's a direct way for the landlord to secure income and maintain control if the original tenant messes up.
Smart move for the landlord. What else?
The landlord can also usually obtain a direct indemnity from the subtenant in the consent agreement, meaning the subtenant agrees to cover the landlord for any damages or liabilities arising from the subtenant's actions or occupancy, another layer of protection for the landlord.
And I'm guessing the landlord will want to prevent a sublease chain reaction from forming without their approval, like the subtenant subletting to someone else.
Oh, absolutely. The landlord will definitely want clear limitations on any further subleases or assignments by the subtenant. They want to maintain control over exactly who is occupying the property. This entire framework, when done right, ensures that all three parties know exactly where they stand legally, minimizing confusion and hopefully preventing future disputes.
Okay, fantastic breakdown. So to recap this, really quite fascinating deep dive. We've explored the fundamental distinctions between subleasing and assignment, understanding that crucial reversionary interest and the concept of privity, who has a direct legal relationship with whom, and how that impacts liability for all parties involved. That's absolutely key for your RES exam.
Couldn't agree more. And we've weighed that double-edged sword of pros and cons for landlords, allowing subleasing from potential financial stability and offloading the burden of tenant hunting duties
Right.
to the very real risks of loss of control, increased property damage, and potential legal headaches or neighborhood disruptions.
And we also delved into the really nuanced considerations in any transfer, didn't we? From the competing interests of all the parties, landlords, tenant, and the incoming transfer, to those vital issues like residual liability, especially that novation, checking creditworthiness, and how critical the specific intended use of the premises is depending on the property type.
Plus, we've untangled the legal framework, thinking about how you draft strong lease transfer provisions in the first place, what needs to go into a clear sublease agreement between tenant and subtenant, and the absolutely critical role of that three-party landlord's consent document in tying it all together and clarifying everyone's rights and responsibilities.
Definitely. And understanding these layers of agreements, these interconnected contracts, it isn't just about passing the RES exam, is it? It's really about being able to confidently advise your future clients and protect their interests, whether they happen to be landlords or tenants navigating these situations.
That's the practical application, absolutely. Remember, everyone listening, property is about so much more than just the physical space, the bricks and mortar. It's really about this complex web of rights, responsibilities, and relationships. And mastering these legal dance steps, understanding how these agreements work, that's what truly makes a real estate professional shine, especially here in the dynamic Singapore market.
Well said. A complex dance indeed. All right. Thank you so much for joining us on this deep dive into the world of subleasing and assignments. Hopefully, you're feeling much more confident now and you've got some powerful insights to bring to your RES exam preparation.
Hope it helped clarify things.
We wish you the very best of luck with your upcoming Singapore RES exam. You've got this.